So integration, how does it affect me and my securities offerings? Hi, I'm Gene Trowbridge, and I'm here with my law partner, Jonathan Nieh, and we're on the Thursday podcast of TBD with TLG. Our topics are always to be determined right before we go online, and it's the Trowbridge Law Group that is doing this. And the reason we're talking about integration and securities offerings today is that Jonathan and I had a call this week, and a call that we don't often get. It's been a long time since anyone has asked the questions about integration, so we thought we would cover it and cover it in two main areas. First of all, the issue of integration is an issue in Regulation D, Rule 502. And 502 is an important rule. The first thing it talks about is the laws on advertising and solicitation. And then it talks about the need for disclosure, leading us to writing PPMs for your offerings. And another thing it talks about is when two offerings or more are created in a situation where the SEC would look at them and say, that's really one offering. You're trying to split it up because you're doing something different. Just as an example, let's say you put together an offering to take in investors so you could buy a piece of dirt. And then you did another offering to take in investors to build the building on the piece of dirt. And you went out and got one loan to build the building. Well, under certain circumstances, the SEC might come in and say, well, that's really one offering. And so the question would be, well, why did you do it like that? Did you do two offerings to take advantage of something or not? I don't know, but that would be an example of integration. The first thing we're going to talk about is integration as how it relates to Rule 506C and Rule 506B offerings. Can you do a 506 and then a 506C and then a 506B right after it, or vice versa, or at the same time? Well, all that's going to be governed by the rules on integration. And Jonathan's going to talk about that right now. How are you doing, Jonathan?
I'm doing well, Gene. Thanks for asking.
Good.
Yeah, so that is one of the issues, or one of the scenarios where integration can become an issue, right? So the whole, concept of integration, like the reason why the SEC has this, it's not really a rule, but I guess let's just call it a rule, right? This integration rule is to prevent issuers, to prevent sponsors from doing one offering that's less restrictive and then using that to get around the subsequent offering that's more restrictive, right? So in the example of doing a 506C and then doing a 506B offering, it's in regards to soliciting your offering, general solicitation. So remember, under 506C, you can advertise, you could generally solicit investors, but under 506B, you can't. You cannot advertise at all. All of your investors have to have a substantive and pre-existing relationship with the sponsor. So what can happen, and what some, issuers try to do, is they'll do a 506C offering where they advertise to everybody, and then immediately after they'll do a 506B offering, utilizing that general solicitation from the 506C, but they're pretending like they already have a pre-existing relationship with the people that they bring in under 506B, even though that they just met them through the advertisement under 506C. So the SEC, they say, no, you can't do that. I mean, this is you're just trying to get around not being able to advertise under 506B. So we're going to say this is a single offering. We're going to integrate it, and when they integrate it, the SEC imposes the more restrictive rules onto the offering. So in that scenario, 506B is more restrictive. So that means that offering that you did, that single offering that they're saying that you did, now has to abide by the 506B rules. And because you advertised, you violated the rules under 506B, and now your exemption is completely blown. So, that could potentially lead to criminal civil liability. Yeah, this is something you should not be doing. But there is, so the question then is, how do I make sure that, if I'm doing a 506C and then a 506B, how do I make sure that it's not integrated? And the SEC has a safe harbor for that. So if you wait 6 months after your first offering closes to do your subsequent offering, you'll be fine. The two offerings won't be integrated, right? And I think that's what your client brought up, right, Gene, when he called and asked about integration. He brought up this 6 month rule, like, can I, if I wait 6 months, then I could, do my second offering. But because he was trying to do two offerings at the same time, he was scared that he wasn't allowed to do that. But I mean, we'll talk about later, I guess, the factors that kind of go into whether those two offerings are integrated. But yeah, so there's that 6 month rule. If you do a 506C and then wait 6 months, you should be fine to do your 506B.
And that's what you and I always suggest to the clients who want to do a 506C. We tell them about this integration issue, whether we use the word integration or not, but we just tell them, you're going to have to wait 6 months from when you close the offering under 506C until you can do your offering under 506B. Because while our clients are advertising for the 506C offering, they can advertise to anyone. So they can find people that will end up in their database but aren't accredited. And so now they want to use those people in the next offering, which would be a 506B. And that's actually one of the reasons we have newer syndicators coming to the market who would like to do 506C, is because it does give them the right to advertise and find new people and build their database. The more experienced syndicators that we have, who have plenty of investors, don't find the need to advertise, so they just stick with the 506B. Isn't that your experience, Jonathan?
Mm-hmm. Yeah, for the most part. I mean, if it works, why change it, right?
Right. So that's the advice we give everyone, and no one's gotten into trouble yet following that advice. So I'm proud of that. The call that I had this week did address the 6 month rule, no question, but it addressed it in a little different way. The caller said that he had heard that the 35 investor rule in the 35 sophisticated investor limitation in Rule 506B would be spread out amongst multiple offerings he might be doing, and he'd have to, if his first offering had 30 sophisticated investors and his second offering had 10, he would have violated the 35 investor rule by having more than 35. What he had heard is that all his offerings would just be simply combined, and they'd add up all the sophisticated investors, and if the total was over 35, it would be trouble. And then he said, but I have also heard that there's a rule that if I do all my offerings at least 6 months apart, I'll be okay. And as Jonathan said, there is a 6 month rule, and it also applies to the issue of sophisticated investors, the number of sophisticated investors you have. And actually, that's a safe harbor rule. So if you want to wait 6 months between offerings that are 506B, you'll be fine. But back to my answer, or my example of you raise money to buy the dirt, and then you raise money to build the building. Let's say you have 35 investors that are sophisticated. in each of those two offerings, but you're doing them at the same time and you've got the same loan and you're building the same building, there's no doubt that the SEC would come in and integrate that and say that's really one offering with 70 sophisticated investors, and you've lost your exemption. So yes, the 6-month rule will help you, but we don't think you're required to wait 6 months, because there are 5 characteristics that the SEC looks at in the first place to see if they want to apply the rule of integration. And we're going to go through these 5. I'll go through a couple, and maybe Jonathan will go through a couple, and then we'll come back and we'll talk about the ones that are going to get you out of trouble here, and let you do more than one offering in a 6-month period of time. And the first one I'm going to talk about is, are the offerings part of a single financing plan? So here in my example of the dirt and the building with one loan, well, the SEC would look at those and say that could be integrated because that's one loan. And the next one would, do the offerings involve issuing the same class of security? Well, that's a little difficult for us because our offerings usually deal with Class A and Class B interests in an LLC. I mean, I guess conceivably we could have one offering that's selling shares in a corporation, and an offering that's selling interest in an LLC going on at the same time under 506B, and we could possibly say that those are different. Jonathan, you want to take the next two?
Sure. Yeah. So the next factor is, are the offerings made at or about the same time? I mean, that kind of goes to the whole 6-month waiting period rule, but I'm not sure if the SEC has set standards of how many days you have to wait. But obviously, if you do an offering and then you wait like 1 day and do the next offering, that doesn't look good for that one. Use your reasonable judgment. Wait. If you wait 6 months, then you're fine because you follow the safe harbor. But yeah, so I mean, obviously, don't do it right back to back. Next factor is the same type of consideration being received by the company. So consideration is just payment. Whether or not you're accepting cash investment or investors are contributing property could be an option. So if both offerings involve cash investment, which 9 times out of 10 it's going to be cash investment, I mean that factor is going to be checked off no matter what, I feel like. You want to do the last one, Gene, or do you want me to take it?
Yeah, I'll do the last one. The last one is, are they made for the same general purpose? So we've got these 5 rules, and it's really kind of guesswork. Jonathan, one of the things that I think helps our clients is the last one I mentioned. Mm-hmm. Are they made for the same general purpose? Well, this month I'm raising money to buy a property in San Antonio, an apartment building in San Antonio. And next month I'm going to buy an apartment building in Austin. Okay. Well, just on that basis, the offerings are for 2 different properties. So I think that's one of the ways that you could break this rule of integration. And then I also think the first one we talked about, which is, are the offerings part of a single financing plan? So you're going to have one loan on the property in Austin and one loan on the property in San Antonio. So those are different loans. They're different buildings. So I think you're pretty safe there that under those 2 situations, you wouldn't be integrated. Now, I'm not totally sure that it's and what I mean and is it all five of those things, are they part of the single financing plan? And is it the same class of security? And are they made at the same time? And are you taking the same consideration? And are you made for the same general purpose? I'm not sure, but I don't see the word in there. So I'm thinking that what we have is the ability to look at different factors and make an argument that it's not a situation where the offerings might be integrated. Can you think of anything, Jonathan, out of those five that you would bring up as an example that we could use to differentiate between our offerings?
No, I mean, I think first of all, it's a balancing test, right? So if it is integrated, they're going to weigh the five factors, right? And some factors weigh more than others. So I think the fifth factor is for the same general purpose, right? If it's the same property, that's going to weigh way more than whether or not it's the time period, right? Whether or not a set amount of time has passed. So I think well, I mean, it depends on the scenario, right? Like for our example, if it's a specific property, then yeah, if it's the same property and the same investors, same type of security, then it's probably going to be integrated. So
back to my example, a piece of dirt and then building the building with two different offerings. I go through these 5 steps and I say, okay, are the offerings part of a single financing plan? It's possible that those two offerings would use the same construction loan and the same permanent financing. So that might be a reason to integrate it. Be issuing the same class of security. Now, I'm going to combine that with, is the same type of consideration given? What if the one offering is between the sponsor and the owner of the land, and the owner of the land is going to contribute the land LLC? It's going to be a security, and in return for the contribution of the land, the owner is going to get a preferred type of interest in that LLC. But here comes the other LLC where they're just selling for cash, and that's not a preferred type of interest. Is that enough? The fact that one group is paying cash and the other group is contributing land, and one person's getting a preferred return and the other one isn't. Is that enough to offset the fact that number 1 and 5 are present? It's the same financing plan, and it's for the same general purpose, and even number 3, it's done at the same time. I have no answer to that.
Yeah, neither do I.
I just don't know.
Yeah.
So I think you could always go for a no action letter or something like that. And of course, a no action letter is a request you make to the SEC. And basically it says, if I do this, SEC, will you come back to me and say, if I do exactly what I said, will you agree to take no action against me? But that's kind of complicated and takes a while to get that. So that might not work. Jonathan, I'm thinking about our clients, and most of our clients do a deal. They sign a fee agreement, they buy a property, they raise the money, they close, they relax, and then a month later or 2 months later, they're out looking for new properties and they find another deal. Not too often do we find clients who are doing more than 2 deals in 6 months, but we do have those serial syndicators that we work with. But how about this for an example? And you and I have worked on this. What if one of our clients finds a seller who has 2 properties, and let's say they're in the same block, and the seller might have bought them at different times over a period of time, and wants to sell them both, but he wants to sell them as a package. And our client comes in and says, okay, I'll buy both of them, but I want to put syndication A together to own one and syndication B together to own the other one. And one needs a little rehab. So I'm going to get a bridge loan on one, and I'm going to get a Fannie or Freddie loan on the other. Well, here we've got two properties from the same seller at the same time with offerings that are probably pretty similar, except for the loan is different, right? And I wonder if the purpose is different because they're for two different properties. That might be something that a client would want to talk to their attorney about before they jump into that. What do you think, Jonathan?
Oh yeah, definitely. I mean, they should talk to us before any deal they get into, right?
Mm-hmm. But that is really, and you can think back at some of the clients we've had that have bought two or three properties from the same seller in different LLCs, because the lender wants, even if it was going to be Fannie or Freddie, the lender doesn't want two properties on the same loan. They want single purpose entities. Yeah. And so that would probably take you into the way we do like a fund, where there's a group of investors who invest in a pool in a LLC, and then the LLC goes out and buys the two properties with separate single purpose entities and gets separate loans. Well, that's already one offering, so we don't have to worry about it. But that was an interesting question, and it prompted, as far as I was concerned, it prompted an opportunity for us to talk about a TBD topic. Anything else to add on this, Jonathan, before we say goodbye?
Yeah, I will say, going back to your example, even if it is integrated, it's only a problem if you have more than 35 sophisticated investors in both offerings combined, right? If you have less than 35 and the two offerings are integrated,
so what?
Fine. Yeah, it's just one offering then. Yeah.
Right. So that doesn't mean you can do a 506C on one of the properties and advertise, and at the same time do a 506B on the other one and
no.
less than 35 investors. Right? You can't do that. All right. Well, that's another good episode of TBD with TLG, and we will, Jonathan and I will see you next Thursday at noon. California time, and boy, we've got a week to figure out what the heck we're going to talk about. Right?
Thinking about it right now.
Okay. Talk to you later. Bye.